morning, my lovely students.
Good morning, sir.
Today is the 23rd day of May 2023, and we are continuing our lectures on Nigerian petroleum law. We have been looking at the environmental aspect or the regulation of the environmental implications of oil and gas operations. And we have said several things. Today we will continue from where we stopped. We are now looking at liability for oil spill and the compensation framework. Are you with me so far?
Yes, sir.
I will start from there. Is that okay?
Yes, sir.
Okay, so naturally, if there is a spill, because recall that our focus has been on what? Oil spill. We have not got into gas flaring yet. You remember?
Yes, sir.
Yes, so if there's an oil spill, the issue is that somebody should be held liable. I've already told us that when the spill occurs, the spiller is mandated to clean up the environment within a particular period, time frame. He must do that timeously under the Nuisance Act. And if he does not do that, he will be required to pay a fine. A fine will be imposed upon him. And I told us that practically, if we were to look at it strictly speaking, if there's a sabotage that leads to the oil spill, it is the person who sabotaged the environment that we want to call the spiller. Is that not so?
Yes, sir.
But because it is almost impossible to apprehend such persons, and even if you do, they will not have the capacity to clean up the spill anyway. In practice, it is usually done by the oil company in question. Are you with me so far?
Yes, sir.
But the next thing after cleanup and remediation, so the spiller, the oil company will be required to first of all clean up the spill, contain it from getting, further, recover as much as he can, and then we'll now start talking about how do we remedy the land, how do we repair the damage to the land. Are you with me so far?
Yes.
And there I said that we have a number of techniques that they use. There's what they call bioremediation techniques. This is where they apply a number of things to clean up the environment. Are you with me so far?
Yes, sir.
So you want to remedy the environment, you have to employ a number of factors or a number of things, if you want to use that word. So let me just use what I have here from my notes for purpose of recording. Remediation, which is the act of putting or restoring a polluted environment back to its previous state, is meant to follow immediately after cleanup of an impacted environment. In order to be effective, it has to be thorough and elaborate, and its aim is to ensure that contamination is eliminated and soil, water, or air quality is restored to such a level as to achieve functionality for human, animal, and plant life. Are you with me so far?
Yes, sir.
Yes, so under the cleanup regulations, an impacted soil is to be remediated after the evacuation of free phase of oil. You want to see regulation 18 sub 4, regulation 18 sub 4. Write it down now if you want to, or you can get it from the recording later. Different remediation techniques may be applied, and this will depend on whether the spill occurred on land or on water. And even if it is on water, is it fresh water or salt water? Are you with me?
Yes.
Different remediation techniques can be applied, and it will depend on, is it salt or is it water or is it land? And even if it is water, if it is salt, you have a different technique. The technique that may function or operate effectively in salt may not operate in fresh. Are you with me so far?
Yes, sir.
Companies have their own remediation procedures as well as cleanup procedures, the common of which is the RENA method, which entails the application of nutrients, in bracket, inorganic fertilizer, tiling, or tilling, irrigation, and periodic turning to ensure uniform aeration. Aeration is AERATION. Are you with me so far?
Yes, sir.
They may also use dispersants or degrade the spill or apply bioremediation techniques for the breakdown of final traces of oil after cleanup. Or they may add nutrients such as nitrogen and phosphorus, which aid rapid microbial growth. Other remediation methods include the use of fertilizers, bioaugmentation, excavation, or the application of thermal desorption techniques. Are you with me so far? Yes, so I said all of that at least to give you some perspective that when the spill has occurred and you have cleaned it up, the environment is already damaged. And the next thing is, how do we bring it to the position where it was before so that the land can be fertile again? Are you with me so far? And so these scientists, this is not law actually. You have to bring in scientists here, environmentalists. Are you with me? Agriculturists, biologists, and all that. They will form a team definitely, and then begin to apply some of these chemicals in order to ensure that they bring the environment up to speed as much as possible. So we want to now look at again the compensation framework again. Liability and compensation. Recall, I told you that if the spill occurs from the pipeline, then the Pipeline Act will apply. Is that not so? Yes. And that act imposes, under that act, Section 11, there is an imposition of liability upon the oil company. By default, the moment the spill occurs from a pipeline, prima facie, the oil company is liable. It's more like a strict liability arrangement, except it can now raise the defense of sabotage or the defense that it was the plaintiff or the claimant himself that contributed or caused the spill. Is that not so? Yes, sir. Other than that, once the spill occurs, prima facie, the burden of proving that you are not liable for this spill moves over to or is imposed upon the company. Are you with me so far?
Yes, sir.
Good. I gave you the case of IPD versus Shelby, didn't I?
Yes.
Excellent. So, and did I talk about restitutio in integrum?
Yes, sir.
Yes. What does it mean? My son, you that just came, have you got the audio from all of them in the past? Yes, sir. That is how I know that you're not serious. You just wear eyeglasses to look serious. You can't deceive me. You mean you have missed about 8 or 9 lectures and you have not met your colleagues to say, what has the man been teaching? Where has he reached? What materials has he given? Are there recordings? Please, Vicky, can I have it? Please, Igeme, transfer it to me quickly. That is how a serious person does. Are you from Bayelsa? Please try for our state. We need you to be serious. So before you appear before me on Thursday, you must have got all the materials I gave the students. Will you do that? You have a smartphone, don't you? Excellent. Get those materials and ensure you are brought up to speed. If not, don't come here. Stay home. Will you do that? Good man. Ole, am I too hard on this man?
No, sir.
Are you sure?
Yes.
We'll have to push him on. Okay, friends. So remember, restitutio in integrum as much as possible. Restore to where we were before. See the case of SPD versus Farah. Please look at it. These are very important cases. SPD versus Farah. And look at Shell BP versus Umuje. Shell BP versus Umuje. I gave us some articles. You saw them?
Yes, sir.
Nobody could say thank you, sir.
Yes, sir.
Did you?
Yes, sir.
Okay, that is how it should be. That is the normal behavior. There's nothing special about it. Are you with me so far?
Yes, sir.
Good. So, and those articles are very, very important. And I want you to look at them. Just look at them. Peace, can you do that?
Yes, sir.
Yes, in one day you can look at them. They will open up your head to discuss, particularly this area that I'm teaching. So thank you, Lord. Can I continue, please?
Yes, sir.
Excellent, people. So now the next thing is compensation. So now, if the oil spill doesn't come from a pipeline, it could be that the wellhead malfunctioned. That is not a pipeline. Are you with me? It could break out from the manifold. Even the well could burst open. Then we'll not be talking about the Oil Pipelines Act here. If we are going to talk about compensation, you remember the Pipelines Act only deals with pipelines and spills occurring as a result of leakage from this pipeline. But nothing is coming from the manifold or the wellhead and all those things. Then what do we do? Next time we meet on Thursday, I pray that there's light. I told you I wanted to show you videos last week. Yeah, so that you will see some of these things when we're talking about manifold, wellhead, pipeline. You have some graphic view. So I have the URLs here. I wanted us to look at them together. You have pictures?
Yes.
I'm not surprised. I'm impressed. Are you hearing me? Are you ready for your presentation?
Yes, sir.
I trust you. Can we continue?
Yes, sir.
Yes, so the aim of compensation, of course, is to ensure that you remedy the person. So there are two things now. You are remedying the land that is damaged, and the owner of the land who has also suffered. Is that also?
Yes.
The owner of the land who has also suffered will also want to be compensated. And for that, in the case of SPDC versus FARA, I will read what Honorable Judge JCA said, that compensation is done with regard of, in view to the market value of the property when taken. It may include interest, and it may include the cost or value of the property in the owner for the purposes for which he designed it. Compensation must also be paid for subsequent, consequential, and prospective future losses, not merely for destroyed property. Are you with me? Yeah. This is what the court held. Compensation must also be paid for the subsequent, consequential, and prospective future losses, not merely for the destroyed property. So I have acquired this land, I have leased this land from Tarila, and I intend to use it to farm for the next 10 years. There's been a spill. My crops have been destroyed. I need compensation for the crops. But I will not be able to use this land for the next 10 years to farm. Are you with me? Yes. And I have bought it from, so I need compensation also for that. Listen to Edozie and JCA. Here he cited a textbook on damages as follows. Beyond physical damage to the land, however, a nuisance may cause annoyance, inconvenience, discomfort, or even illness to the plaintiff occupier. Recovery in respect of these principally non-pecuniary losses is allowable and may be regarded as part of the normal measure of damages. So I said here that compensation should also be paid for the suffering of individuals as a result of damage to the land. I want you to take your time and look at that case, SPDC versus FARA. You cannot do petroleum law without looking at that case. And if you don't look at it, don't say I did not refer you to this case. One reason is because you know that a spill, the impact of a spill can be continuous. A classic example is the Ejama Ebubu matter. I tried to look for the citation of that case. I can't find it, but I will get it. Ejama Ebubu is a very, very popular case where they brought an action against Shell for billions of naira, billions, I think 70 billion, for a spill that occurred in the 70s. But according to it's an Eleme community, they say the impact of the spill continued up till 1991. It occurred in the 70s, I think around the Civil War. But the impact of the spill continued till around the 1991. And so they took Shell to court and got judgment. It's a very serious matter. When they got that judgment, Shell went, of course, up to Supreme Court and lost. Paid the money, they began to do one magic or the other. They went back to Supreme Court to review the judgment. Supreme Court said, no, you must pay. And the money was so much that Shell decided to take the Nigerian government to arbitration, international arbitration, that this judgment is a ploy of the government to get money. It's amounting to a form of expropriation. We'll talk about it. Is this second semester we're in now?
Yes.
Yes, so we'll talk about it in the course of this lecture. So that is a case I want you to also look at. I will try and get a citation for you. Is that okay?
Yes, sir.
So that you'll be able to look at it. But it is all over the internet. Court orders Shell to pay 122 billion damages for oil spill. I think in the end, Shell and the community, they came to some form of agreement to reduce the payment and all that. But I said all of that just to establish that that an oil spill, the impact of a spill can be what? Can be what? Continuous. And so when you are looking at going for compensation, it's not just for the crops, the economic crops that you have suffered now, but you may also be asking the court for general damages for the continuous suffering that the people have suffered. It could be health problem, for example. Are you with me? As a result of this spill, the environments of this place are now suffering from bronchitis. People have the life expectancy has been cut short. Yeah, so those are all some things that you may also want to look at. So let's talk briefly again about defenses. I've already mentioned again the defense of sabotage. When it is an oil pipeline matter, remember that Section 11, subsection 5C allows the oil company to raise certain defenses. One of which is that the personal default was caused by the victim. The default was caused by the victim. The man claiming damage is the one that caused the problem. Then, of course, sabotage. Are you with me so far? Just to emphasize that the defense of sabotage is intended to prevent criminally minded individuals from benefiting from their own actions. It is intended to prevent criminally minded persons from benefiting from their own actions. That is first part of it. And secondly, of course, is that the person should not suffer for a wrong that he did not commit. Are you with me so far?
Yes, sir.
Yes. So it would be wrong if me as the oil company, I have built a pipeline infrastructure and I've relatively made it secure. Somebody damages it and there's a spill, I will not have to pay. No. I will clean up the spill, but I will not pay compensation. I will not pay compensation. So that among other things, I want to also discourage people from also damaging. Because somebody can go under the cover of night, damage his own property, and then claim compensation. In insurance, it's called what? Arson. Arson. It happens a lot in insurance, where a person burns down his own house and then goes to claim what? Yes, payment. Yes, and so they start a lot of investigations and bring experts to trace where the fire started from. That same concept is brought here as well. Are you with me so far?
Yes, sir.
So the oil company now raises the defense sabotage. And like I told you, the default defense now is what? Sabotage. Once it happens, before they even investigate, just take a sabotage. So it's something that companies now do. Overturning this defense is an uphill task for the poor indigenes of the Niger Delta. That is the issue. So when the company has raised the defense of sabotage, if they can raise it successfully, they have to prove now. Then the body will shift. You are doing evidence now. Yes, there's always a shift. Is that also? Yes. Until we're able to now say the last person that will lose the case, if no further evidence is adduced, is the person that will have the burden to prove. So when the company has raised evidence and the defense of sabotage and all that, it will now be for the indigenes to now rebut it. And I said overturning that defense is not easy. But I pointed out just to emphasize that the defense of sabotage is not an automatic shield. It must be proved that reasonable diligence had been exercised to secure and supervise the facility against interference by third parties. I also referred it to the decision of Manuel J. In 1976, where he said evidence must be led to either identify such third party or show circumstances to lead to an irresistible conclusion of the act of the third party whose act was neither unforeseeable nor controlled or controllable by the defendant. Are there questions? Are there questions? Okay, so we are looking at compensation. Compensation must be fair and adequate. Are you with me? As far as the oil and gas industry is concerned, there are different provisions for compensation. First of all, under Section 44 of the Constitution, Section 44 of the Constitution, if you acquire land, if government acquires your land and gives it to an oil company, government must compensate you, and it should be fair and adequate. That one is for land acquisition. But now under paragraph 37 of the first schedule to the Petroleum Act, just the Petroleum Act, like I said, is being phased out now. is being phased out. I'll read what we have here. The holder of an exploration license, oil prospecting license or mining lease shall, in addition to any liability for compensation to which he may be subject under any other provision of this act, be liable to pay fair and adequate compensation for the disturbance of surface or other right to any person who owns or is in lawful occupation of the licensed or leased land. Is that clear? Are you sure? For the disturbance of the surface or other rights to any person who owns or is in lawful, so you compensate either the owner, thank God for that, or the person in lawful occupation. Can we close those places? Can we on the AC, please? Yes, there. No problem. We will continue. Can I continue?
Yes, sir.
Good. So remember again, I showed you the PIA section 101 appears to have taken over from what we used to have as paragraph 37 of the first schedule to the Petroleum Act. On the lights, please. Good. Section 101 of the PIA now appears to have elaborated on the provisions which we had under paragraph 37 of the first schedule to the Act, and I'll just read some part of that. Is that okay?
Yes, sir.
Good. A licensee or leasee shall not enter upon, occupy, or exercise any of the rights or powers conferred by its license or lease in relation to, I've already mentioned that area that is sacred, venerated land. Did I say that?
Yes, sir.
So generally, land that is sacred or venerated, leave those places alone. Land that is set aside for public purpose and all that. So you see all that in section 100, subsection 1. And if at all you must enter such lands, and use privately owned land, you must be ready to pay fair and adequate compensation. So again, this provision here, section 101, subsection 1C, you can link it to section 44 of the Constitution, that deals with you paying compensation as a license holder or leaseholder. If you want to use somebody's land for your oil and gas business, be ready to pay him fair and adequate compensation. Are you with me so far?
Yes.
But that is not our focus today. The other part now is subsection 2. A person shall not, in the course of petroleum operations, injure or destroy any tree or object which is of commercial value or the object of veneration to the people resident within the area. It should not damage or destroy any building or property or disturb or damage the surface of the land or any other rights to any person who owns or is in lawful occupation of the surface area covered by the license or lease. Don't destroy the land. Either if it is owned by somebody or somebody lawfully occupies. Are you with me so far? Sub 3 says a licensee or leasee who causes damage pursuant to subsection 2 of this section shall now again pay fair and adequate compensation to the persons or communities directly affected by the damage or injury. I don't like this word, directly affected. What about people who are indirectly affected? Are you with me? It's a deliberate attempt to frustrate, because the person may not be directly affected. It's not my own property, but the air he starts to inhale may affect him one way or the other, and if he brings an action, the company may raise this defense, and we don't know how the court will interpret it. Are you with me so far? So that is the main thing you need to know. Sub 2 says, do not destroy, do not damage. Sub 3 says, if you do, pay fair and adequate what? Compensation. Sub 3 now says, how do we determine the amount of compensation? The amount of compensation payable shall be determined by the commission and prescribed by regulation. I think that is a good one. The PIA for the first time has now imposed upon the commission the responsibility to determine compensation. Before we get to the courts, let's address this thing at a more flexible and perhaps confidential environment. The commission will now act as a judge, but again, we don't know what will happen if this thing gets to the courts, because the courts are always very jealous of their jurisdiction, and anything that appears to encroach on that jurisdiction, even if it is for the public good, they will strike it down. You see, Section 6 of the Constitution has given powers to adjudicate to the courts, and so if you attempt to adjudicate, they may strike it down, but we don't know how it will go. But for now, the amount of compensation payable shall be determined by the commission. The question, through a regulation, the question is, can a person challenge that determination in court? Are you with me? Yes. What is the basis upon which the commission arrives at this compensation that the company should pay for either damaging a tree or a venerated area? So those are some of the things I want you to also look into. Some of you will soon get to year 5 and you write your project. There's so much here that you can write on. Where a licensee or lessee fails to pay compensation pursuant to blah blah blah, the commission may apply sanctions. So the commission determines the compensation. If you refuse to pay, they will apply sanctions. But remember that you have to interpret this section side by side with the Oil Pipelines Act. For the Oil Pipelines Act, once there is damage, you pay compensation and you have those defenses. But for every other damage, then the commission will be able to determine compensation payable. Because under the Pipelines Act, I think we will look at that act in the course of this lecture when we look at transportation of petroleum. Under that act, the court is empowered to determine compensation. Are you with me so far? Yes. And here the PIA is saying the commission will determine the compensation. I hope these two provisions will not be interpreted as being in a conflict one to another. Are there questions? We are looking at liability and compensation. Now, liability under the common law rule, let's look at common law rule of Rylance and Fletcher. Rylance and Fletcher. And I would like somebody to help us and explain that rule. Somebody who just left year 3 and did the law of thoughts. Blessing, where is comfort, my daughter? Blessing, help us with the rule in Rylance and Fletcher. Did you pass thoughts? Or are you writing it again?
No.
You passed it. This is a very common, very basic rule in thought law. Yeah, somebody should help her. They kill the helper.
So in that case, the plaintiff, the defendant, builds.
No, don't tell me the facts. What is the rule about?
That if anybody brings a non-natural thing upon his land,
Yes.
if the non-natural thing escape and cause damage, will be held liable.
Simple. Particularly when it was foreseeable that there's a possibility of that thing escaping. Is that not so?
Yes.
So this remedy imposes a strict liability on a person who for his own purposes brings on his land and collects and keeps there anything likely to do mischief if it escapes. Such a person must keep such things, therefore, at his own peril. If he does not do so, he is prima facie answerable for all the damage which is the natural consequence of the escape of that thing. This rule has been used by claimants in actions against petroleum companies since it does away with the requirement of proving fault and imposes strict liability on the defendant. Again, you want to see Umuje versus Shell BP. Umuje versus Shell BP, where a claim was filed for damages to the claimant's ponds, lakes, and farmlands due to the escape of oil waste from a pit controlled by the defendant. Relying on Ryland versus Fletcher, the Supreme Court found that the defendants were liable for the damage. See also SPDC versus Tiebo. You must read these cases. As I'm giving you, look at them. You cannot go through this course and not know SPDC versus Tiebo. And Peremabri case, why are you here then? You must look at it. Please, it's 1994, NWLRO, you see it there. It's all over the internet. So much has been written about it. Now I'll read what Freiner said. That one I sent you his articles. An escape of crude oil or oily waste fulfills all the conditions required to impose liability under the rule in Ryland versus Fletcher. Accordingly, any dangerous incident involving crude oil can be potentially prosecuted. The defendant is strictly liable for damage which removes the plaintiff's burden of proof. It is not necessary for the plaintiff to prove any negligence or breach of duty of care in this case. Are you with me so far? Yes. So that again is another heading or basis upon which liability can be imposed upon a person for the damages that have been caused to the land. Are you with me? Yes. Yes. Under the rule in Ryland versus Fletcher, we impose a strict liability upon you if we are able to find that you brought this petroleum into this land or into this manifold, or as the case may be, and there was this possibility that something may happen that will cause it to spill and all that. That notwithstanding, there are still defenses. So I'll just run through some of them. Or can somebody who did thoughts last year tell me, Egeme, tell me some of the defenses to the rule in Ryland versus Fletcher? Yes, please.
Okay, one of the defenses out of God and out of the God person.
This one go school. You go school. You hear me? That is how it should be. The course you did just last year should be like me now. If I forget it, nobody will blame me because I did this course last, 1999. That's how many years ago? 24. So if I am stumbling small, nobody will blame me. Of course, I will still have an idea of the main principle. But you are young, fresh students. All of you are young here. I just did it 3 or 4 or 5 months ago. So it should be in your hand. As I ask you this dish. No be so? Please work hard though. Yeah, so some of their defenses that you can see raised that the damage was due to an act of God or by virtue of the default of the plaintiff. Is that also?
Yes.
Yeah, it was his own default that led to it, or it arose with his own consent. It arose with his own consent, and of course, or as an act of sabotage and all that. So you want to see the case of Shell versus Otoko. Shell versus Otoko. Shell versus Otoko. Almost all the cases is Shell. Shell versus Isaiah and Shell versus Enoch. But these 3 cases I gave to you again have to do with sabotage. Sabotage. Good. Can we continue, please? You have a class by 12.
Yes,
Is the man coming?
yes,
Which course?
evidence.
Excellent. Can we continue?
Yes, sir.
The next heading upon which liability can be imposed, of course, is negligence. Negligence. To establish negligence, what are the core conditions that must be met? My daughter Kuro. Yes, my dear.
That there was a duty of care.
Okay.
That there was a breach of that duty of care.
Okay.
And such breach led to a damage of.
Excellent. Excellent. This one goes to. This one goes to. Can we continue? So here you are trying to bring an action against it. So a person who has suffered damages upon his land by virtue of an oil spill and is claiming against the oil company can claim that this breach occurred as a result of your negligence. Your negligence has caused this breach. You owed me a duty of care. You failed to meet that duty. And because you failed to meet that duty, I am now suffering. So I want damages. I want to be compensated. Are you with me? Good. I want to point out here again that proof of the absence of reasonable care on the part of oil companies is not easy because of the highly technical evidence that will be required from experts, scientists, and all that. And poor farming communities are often unable to procure the best experts that they require. So I gave 2 cases here which you want to see. Atubin, ATUBIN, Atubin versus Shelby. In that case, a claim for compensation due to the leakage of crude oil and gas and other chemicals from pipelines under the control of the respondent was dismissed due to lack of proof of negligence. You want to also see Chinda versus Shelby. Can we continue?
Yes.
Good. See also seismograph service versus Mark. You will find all of them in those articles. Please, can we continue?
Yes.
Okay. So proving negligence is not always easy, like I said, because here you are proving fault. If it's a strict liability case, you are not proving fault. Is that not so?
Yes.
We don't want to know whether you are at fault or not. Once we catch you in the exam hall with a phone, you are guilty. It's strict liability. So you have to check yourself 10 times before you enter the hall. We'll catch you with this kind of paper, you are guilty. Strict liability. But when we come over to negligence, you have to now prove that the person actually was negligent. That means if you had not been negligent, that particular damage would not have what occurred. So here the burden of proof moves to the claimant. In strict liability cases or oil pipeline cases, the burden of proof moves to the oil company. So say, my Lord, it appears that I'm guilty or liable for this damage, but I want to raise the defense of sabotage, and I want to argue that this was an act of God. I don't know why they call it act of God anyway. God is not a destroyer, but funny enough, that has been part of our terminology now. Yes, natural disasters and all that. Now say it's an act of God. A Chevron tanker driver was drunk, and there was an accident, killed people, and they say it's an act of God. God does not get drunk. It's not God. But let's not talk religion. Let's move on. Is that okay, peace?
Yes, sir.
Good. In the case of seismograph service versus Mark, I will read again. The plaintiff claimed compensation for damage from the destruction of his fishing nets by a seismic boat. The Court of Appeal found that the plaintiff did not establish that the oil company breached the duty of care towards him, and the fact that the seismic boat tore through the fishing nets was regarded as an insufficient proof of negligence in itself. In essence, the allegation that the vessel tore through and carried the floaters away is not by itself suggestive of excessive speed or any amount of negligence. So what I'm trying to say is that the courts often tend, or before this time, they tended to side with oil companies, making it very, very difficult to establish negligence against them, particularly when you have to now bring expert evidence, and they will also bring expert evidence. I will read what Frinas noted on this case. Frinas commented that this case illustrates that proving negligence can be difficult in oil-related litigation because of the technical nature of oil operations. The plaintiff must prove that the oil company violated an acceptable standard of behavior. But environmental or technical standards are usually based on sophisticated scientific knowledge and data. For instance, the Petroleum Act provides that an oil company must adopt good oil field practice. The oil industry normally has a superior technical knowledge compared to the individual litigants. Consequently, it may often be difficult for the plaintiff to argue that the oil company was unreasonably negligent or did not adopt accepted standards during its operations. I hope it's clear. Are you sure? I'll still read what Friend has said. For purpose of your notes, you can take it. I'm coming. No, I don't think this is necessary. Okay, so. But in proving negligence, there's also a principle that can help the plaintiff in some instances. It's called the principle of res what? Res ipsa loquitur. Can somebody explain it to me? Eh? Yes, explain. Give me an example of how it works. Yes?
For instance, if an accident occurs, if an accident occurs and it was clear that it was if let me say sorry sir.
No problem.
Let me say, for instance, a driver who
Yes.
was drunk and was driving and an accident occurred. Actually, from the way it is, like the way from his appearance, the way he's behaving, people will know that yes, it's from what he did, from his drunken state. So it's clear that there is no need to prove that other aspect. The fact speaks that.
I hope you people are clear. Eh?
Yes, sir.
Are you clear, sir? Are you sure? The existence of certain facts, once you can prove them, will remove from you the burden of going further to prove negligence. Once those facts exist, we can infer the existence of what? Negligence. And it is now the burden of that person to now rebut it. So like she is explaining, an accident has occurred. A man was driving and an accident has occurred and people have died. We check his bloodstream. The alcohol content was excessively high. Are you with me?
Yes.
The facts speak for themselves. It is no longer for us to now prove that he was driving recklessly or he was overspeeding. It's not necessary again. The accident has occurred and he's had excessive alcoholic content on him. So we'll say that he was negligent. He owes the people on the road a duty of care. Is that also?
Yes.
To drive his car safely. If I'm just coming from Port Harcourt now. I did not follow this road. Instead, I followed is it Okaki Road? You know that road? You know that road? Yes. Now, today is market day, so you see all those market women blocking the road. I have to drive softly, be honing, clearing, honing till you pass. You can't go and drive recklessly there and damage somebody. You know, so I owe them a duty of care. So when they find that this man was drunk, then res ipsa loquitur, we will say that the facts speak for themselves. No need to go further to prove what? Damage. A negligence. except he is not able to rebut it. Are you with me?
Yes.
Let me read what I have here. Here, a lawsuit based on the claim of negligence may succeed even if the plaintiff cannot prove that the defendant breached a duty of care, because res ipsa loquitur, the facts speak for themselves. Then there's a case I want you to look at. MON versus Shelby. Write it down. Mon versus Shelby. In that case, the plaintiffs claimed compensation for damage from an oil spill. They won the case with the court justifying its decision as follows. Negligence on the part of the defendants has been pleaded, and there's no evidence of it. None, in fact, is needed, for they must naturally be held responsible for the results arising from an escape of oil which they should have kept under control. Tarela, I don't know if you understand. Is it clear? I'll read it again. In this case, you know, the whole rule of the underlying principle of civil litigation is that he who asserts must prove. And every fact that you plead, you must tender evidence to it. When you bring an action against somebody, you'll be required to file what they call pleadings. Then the person will also file his own pleadings. Those pleadings, we usually call them statement of defense and statement of what? Claim. There are still other documents that we call pleadings, but at this your level, just take it statement of claim and statement of defense. And in your pleadings, every fact you plead, you are required to adduce evidence to it, except it is a fact that the court can judicially take notice of. For example, the court can judicially take notice of the fact that Muhammadu Buhari is president of Nigeria. Have you come to that in evidence law? Facts which the court must judicially notice. Have you come there? Okay, the man will teach you soon. Mr. Federekum, I believe you'll get there soon. Are you with me?
Yes, sir.
The court is meant to take judicial notice of certain facts, one of which is all the laws of the federation. The court is meant to take judicial notice of them. You don't need to prove them. If I say section 2020, the court must take judicial notice of that law. Then the court must take judicial notice of the fact that Buhari is president of Nigeria and a number of other facts. Are you with me so far?
Yes, sir.
Here they are saying, the judge is now saying, but apart from that, every other fact you plead, you must adduce evidence. If you don't adduce evidence, then that pleading has failed. Negligence, so yeah, they pleaded negligence. Negligence on the part of defendants has been pleaded. But there is no evidence adduced to prove that. The judge is saying none is in fact needed. We don't need to prove. For they must naturally, the defendant must naturally be held responsible for the results that arose or arising from an escape of oil which they should have kept under control. The oil is spilled from your tanker. For example, you have this tanker or barge that is carrying petroleum, and then there's an accident and the oil is spilled, and the man is bringing an action against you that the oil is spilled because of your own negligence. Normally he has to prove. If not, he will not get judgment. Are you with me?
Yes.
So you know that the Mbiama Road now is bad. I mean, from between Mbiama and Ahoda because of the flood.
Yes.
Is that also?
Yes.
And so a tanker that is going there may fall, may collapse. If the government now puts a warning, tankers are at high risk of falling. Please don't pass. Are you with me?
Yes.
Until we fix the road, only small cars should pass. A Chevron and tanker is now passing there with petroleum, and it collapses, it tumbles, and petroleum spills. The man is claiming negligence. Are you with me? Say it happened because you were negligent. You already knew that there's a possibility that this. Are you with me so far?
Yes.
Because you say the facts speak for themselves. Because number one, you already knew there was a high tendency that this thing could happen, and you were even warned not to have taken that road. I'm just giving you an example. Are you with me?
Yes, sir.
Yes. So I'll read again what Friend has said here. The case of Mon versus Shelby illustrates that shifting the burden of proof from the plaintiff to defendant can significantly improve the chances of litigants who sue oil companies. If the principle is invoked, an oil company must prove that the oil operations constituted no harm to the plaintiff. Please, I want you to go and look up these cases and then come to your conclusions. If you have issues or questions, we'll take them together when we meet on which day? Thursday. But Thursday, I want us to enter into gas flaring. Let's continue. We have 20 minutes more, then we'll take our daughter's presentation. Now, another heading I want you to look at is the heading of nuisance. Nuisance. Victoria, my daughter, help us. What is nuisance about?
Nuisance. It's a situation where someone causes disturbance in the region via some kind of accident, sound, or
Okay, you have some idea. Yes, can somebody elaborate further? My son, what is your name? Do you know about nuisance? Please help us.
Nuisance is like a case where someone causes discomforts for either a private person or for the public.
Okay, excellent. Discomforts. Can somebody still put it better? Yes. Can somebody put it better? Yes, please. Let me hear you, my daughter.
Nuisance, I mean, when somebody, forgetting what I want to say.
Yes, Grace.
So, nuisance is a situation whereby the actions or doings of someone causes discomfort.
Annoyance.
Yes,
Discomfort,
annoyance
yes.
to a third party, to someone else.
Good. Sit down. So naturally, everybody should be entitled to some level of peace and comfort and freedom from vexations. Is that also?
Yes.
And it's possible that the act of another person can now begin to trouble you. A good example is sound. Somebody blaring his speaker unnecessarily high for a long period of time. Yes, there could be some unavoidable nuisance. There's a birthday party, 1 hour, 2 hours. You have to be ready to bear with that, particularly because you're in Africa. Is that also?
Yes.
There's a crusade around 1 day, 2 days. But if it is continuous, if it is done at a time when you want to sleep, 2 o'clock in the morning, that's when your neighbor wakes up and begins to pray. And he prays at the top of his voice. It has become a nuisance. You know what happened in the US recently? 2 weeks ago. You know, in America, everybody can have gun.
Yes.
Yeah, so this man had a gun and he was doing target practice. And you heard of it. And the lady, the neighbor just had a baby. So he was doing target practice, shooting. And they went to meet him. Okay, I beg, the thing where they shoot, if they disturb newborn baby, we won't sleep. And he got offended. I have a right to make use of my property. Nobody can stop me. Nobody to hell with you. As he's talking, he has gone to the room to load his gun. And he crossed over to the property and killed 8 people. He wasted them. Yes, I think he has been apprehended now. Yes, that is one of the most dangerous countries. They are always giving travel advisory to their citizens when they come to Nigeria to be careful. Me, I don't even want to go there. Because somebody had been trying to go to America for 10 years, looking for visa. When he finally got the visa, he went to America. He was moving on the road. One white man just came and said, why are there black people everywhere? Black people, they want to take over this country. I need to kill one. You know the person he killed? Is that man who had wanted to go to. Yes, I read it. Just shot him. Terrible place. So what am I trying to say? Nuisance could be noise. It could be smell. You remember?
Yes.
Yes, an offensive odor. An offensive odor. You are living with people and you are cooking with all this garlic and ginger. It's very offensive. You can manage it too, because you are using it maybe for medicinal. Are you with me?
Yes.
But the people around, the smell is very irritating. You have to look for a way to address that. You now have a poultry here, and the chickens or pigs are not defecating, and then it's releasing noise. All those things are wrong. And so the law allows us to claim some relief, either by injunction or damage. Is that also?
Yes.
Yes, and all that. So public nuisance, private nuisance. Private nuisance protects only property interests, and the claimant under this head is unlikely to succeed in the case of oil pollution, except of course it is his own property that was affected. A single individual cannot sue for a public nuisance. Then we'll now talk about public nuisance. You know, for public nuisance, here your own property is not affected directly, but what the person has done is affecting the public. It could be like it's affecting the road. There's an oil spill on the road. Are you with me? Or you have spilled the river. The river doesn't belong to you, but you are from Peremabri community and the whole river has been spilled. And you bring an action as an individual against the oil company for public nuisance. The law says you cannot succeed without first of all establishing that you have suffered peculiar damage over and above what the rest of the public. Is that not so?
Yes.
You remember now?
Yes.
Good. So I just read what I have here. An action founded on public torts can only succeed if the claimant can satisfy the court that his personal rights infringed by the tort exceed those of other members of the public, and secondly, the state has neglected to act in prosecution for that tort. So there have been a lot of changes around this line, and I want you to also note them. Please look at the case of Amos versus Shell. Amos versus Shell. Please look it up, on private news, and see the case of seismograph service versus Akpo. Seismograph service versus Akpo AKPO RUOVO. You will get all the citations from the article I sent you by Frinas. Please look it up. Look it up. Now let's talk briefly about access to courts. Locus, the problem of locus standing and access to the courts. And I think we'll stop there. Again, you want to see the following cases, please. Shinda versus Shelby. If you like, read them. In fact, you must read them. Not if you like. Shinda versus Shelby. Shell versus Tiebo. Mon versus SPDC. See Adediran. Adediran versus Inland Transport. I will not give you any citation. It's all there in the article. See Oronto Douglas versus Shell. And see Oil Pollution Watch versus NNPC. Oil Pollution Watch versus NNPC. Good. Now, so we'll stop here. What will happen is that you will look up these cases and you will do presentations. You will look up these cases. Peace is doing her own today. Egele, yes, Egele and Victoria, the two of you, and you, Blessing, the three of you, you will look up these cases. Your presentation carries 5 marks, and the three of you will present here. Next tomorrow may be too short for you. Upper week, upper Tuesday. Is that okay?
Yes.
I want you to look at the challenges of locus access to the courts as it was before, and the changing trend the current position that the Supreme Court appears to be putting forward in Oil Pollution Watch versus NNPC. In public news, in access to the courts, you can look up at me now. One of the challenges people have had in bringing actions against oil companies have been access. How do you have access to the courts? First of all, you have to determine the court that has jurisdiction. And it wasn't always easy. Even till now, there could still be some issues. If it is a claim for land, who owns this land? Then you go to the state high court. Shell has entered into my land. Shell has acquired my land. Shell is using my land to do oil and gas matter. They've not compensated me. They've not notified me. Don't go to federal high court. You go to state high court. Bayelsa State government has seized my land. They have given it to Mobile to start oil platform there, whatever, or gas gathering project, without adequately revoking my right of occupancy, either deemed or statutory. Do you know about deemed right of occupancy
Yes,
and statutory? What's the difference?
you did before the act start. Deemed right of occupancy.
Yes.
And those people that acquired land before the land use act.
Okay, people that particularly in customary areas, people that were already in possession, they were deemed. I think that should be, is it 34 or 36 of the Land Use Act? I've forgotten. They were deemed to have had a right of occupancy that continues even after the enactment of the Land Use Act in 1978. Are you with me so far?
Yes.
Yeah, so the issue in the past was, so access to courts, if it is a case for land, they go to state high court. But if you are now wanting to claim compensation arising out of oil operations, you have to go back to section 251 of the Constitution that vests exclusive jurisdiction of the Federal High Court. In the past, both courts had simultaneous or concurrent jurisdiction. But I think from 1993, they began to confer exclusive jurisdiction on the Federal High Court. Are you with me so far?
Yes, sir.
State High Courts can't come in. So that is the first issue you want to look at in access to courts. Access to the courts. The another problem they had, or that many people had, was locus standi. If you are suing in a representative capacity, an oil spill has occurred, it has damaged fishes, it has damaged land, it has damaged creeks. Are you suing in your personal capacity? Is the land your own? No, it's not my own. It belongs to all of us. Are you a representative of the whole Peremabri community? Who gave you that authorization? Are you with me so far?
Yes, sir.
Those were some of the challenges that people used to have. So when you look at Chinda versus Shell BP, you'll be able to see an SPDC versus Tiebo. But of late, there have been some issues, there have been changes. For example, Oronto Douglas versus Shell. Oronto was from Okoroba. The federal government wanted to commission the LNG project in Bonny, and he was not comfortable that they had not conducted an EIA, Environmental Impact Assessment. And so he went to State High Court, I think State or Federal, and he lost the action, and they went to Court of Appeal. And one of the issues that Shell raised in that matter was again the issue of locus. Is he from Bonny? Is a public person? Can a public individual sue for a breach of a statute? Does he have the locus? Is it not the federal government? Is it not the state government? Is it not the Attorney General that can sue? Are you with me so far?
Yes.
What if the Attorney General for political purposes refuses to sue? Can a private individual bring an action? So for a long time, our judges were very conservative and did not allow private individuals to be able to bring action when a public right has been breached. That's why I wanted to look at Shinda versus Shell and Shell versus Tiebo, Oronto Douglas versus Shell. But recently, there has been some changes. So you start with Adediran versus Interland Transport, see what the court has said, and now you conclude with Center for Oil Pollution Watch versus NNPC. Are you with me? Among other things, that case now for the first time agreed or recognized the rights of NGOs to be able to sue when there's a public right. It's a landmark decision. I'll read what. Can I read what I have here, please?
Yes.
The appellant, an NGO, had sued the respondents, the NNPC and others, for neglecting its pipelines in Acha Autonomous Community in Isukuato local government area of Abia State, which is alleged later resulted in an oil spill which affected the environment and polluted the potable water relied on by the community. The respondents, in filing his defense, raised the defense of or the issue of locals and argued that the appellant did not have the right to institute the action since it did not show that it was a member of the community, nor did it suffer any damage as a result of the oil spillage. Are you with me?
Yes, sir.
Yes, so you are not from that village and you did not suffer any oil spill. The matter was dismissed by the two lower courts on the basis of absence of locus on the part of the appellant, but the Supreme Court relied on a number of senior lawyers as amicus curiae. What does that mean? Amicus curiae. Excellent. To advise it on the way forward in the matter. After hearing their submissions, the court reviewed a number of local and international authorities and concluded that the appellant has the right to institute the action. There is nothing in the Constitution that says that the Attorney General is the only proper person clothed with standing power to enforce the performance of a public duty or to institute public interest litigation such as the instant case. Are you with me so far?
Yes, sir.
Justice Akas stated that there is no gainsaying the fact that there is increasing concern about climate change, depletion of the ozone layer, waste management, flooding, global warming, decline of wildlife, air, land and water pollution, both nationally and internationally. Countries and organizations are adopting stronger measures to protect and safeguard the environment for the benefit of the present and future generations. The issue of environmental protection against degradation has become a contemporary issue. The plaintiff appellant, being in the vanguard of protecting the environment, should be encouraged to ensure that the actions or omissions of government agencies or multinational oil companies that tend to pollute the environment are checked. Since other Commonwealth countries such as England, Australia, and India have relaxed their rigidity in the application of the concept of local standing in public interest litigation, Nigeria should follow suit. The communities affected by the spillage leading to the environmental degradation may not muster the financial muscle to sue, and if good-spirited organizations such as the plaintiff is denied access to sue, it is the affected communities that stand to lose. Good judgment, fine reasoning. So this is where we are. And so I want to see in your presentation, I want to see slides. My daughter, have you prepared the slide? Good, you have not sent it to me. Send it to me on WhatsApp. I want to see your slide. Are you with me, my son?
Yes.
You are the leader of the team. Where are the other people in that team?
Yeah.
Number 3, good. So when you are meeting, let me know on WhatsApp. I see the picture. You let me know, sir, we are meeting. So anybody who is not in the meeting, I will know. You put heads together. You gather those materials. Don't go and read the summary of somebody. Somebody summarize it and come and give me. I will know. You go to the library. If you cannot get to the library, your papa na lawyer now. Go to your father's chambers. You will see enough of those authorities. The ones you cannot get, let me still know. Is that okay?
Yes, sir.
Then you read. You summarize. I want to see your analysis. It doesn't have to be too long.
Sir,
Then-
all the cases.
I gave you those cases now, yes. That's your presentation. You can divide the work among yourselves. You can say, you read this one, you read this one, all of us read this one. Or all of you should read this and this last one I gave. I want to see your analysis. Are you with me so far?
Yes.
Yes, if you do it well, you get your point. At least you should get up to 4 points. To get 5 will be very hard, but you should be able to get up to 4 if you do a good job. So my dear friends, when we meet on which day? We should enter into gas flaring. I may point out 1 or 2 things about this compensation as well. But if I don't, so I said access to court. I talk about the problem of local standing. I talk about the problem of what else? Jurisdiction. Then there's another thing I forgot to point out. It's the issue of timing. We used to have what they call statutes of limitation. And most of these statutes of limitation, we say file action within 5 years. If it's a land matter, 10 years. Under the old NNPC Act, you must bring an action against NNPC within 1 year. After 1 year, the matter is statute barred. So that also was a major problem. If you go to my Telegram channel, there's an article by a professor Bayo Adela Ragbe, very good article. I have posted it there on limitations and all that. So please look it up again and come to your conclusions. My daughter, come and do your presentation. Off the video.